You've probably heard about the ruling from a district court judge in Florida that struck down the CDC's mask mandate on public transportation. There's been plenty of discussion about what this means, how people have reacted, and the fact that the Biden administration is appealing this decision. What has been lost in most of the conversation is the fact that the judge did not find the rule unconstitutional. But what does this fact mean for the American people? Well, we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. I'm glad you could join me. My name is Paul Engel, and listen, if you'd like me to come speak at your event, I'm putting together tour dates. I've got a couple of dates in the works. Do me a favor, head to constitutionstudy.com/tour. I'm still updating the page, but there's a form on the bottom of the page where you can tell me that you'd like me to come speak at your event. It doesn't need to be a big event. It doesn't need to be a special event. It could just be a group of patriots that get together and would like to have someone come talk to them. Now, I'll talk some more about this at the end of the video, but for now, let's talk about the judge's opinion about the mask mandate. Reading from the judge's opinion, we get some of the background for this case. As travelers have been reminded for more than a year, federal law requires a mask in airports, train stations, and other transportation hubs, as well as on airplanes, buses, trains, and most other public conveyances in the United States. Failure to comply may result in civil and criminal penalties, including removal from the conveyance. This masking requirement, commonly known as the mask mandate, is a Centers for Disease Control and Prevention regulation published in the Federal Register on February 3, 2021. I've made my position on mandates pretty clear in these episodes many times. I have flown with a mask not because the government required it, but because a private company did so. Yes, they required the mask because of an illegal government order, but that was between them and the federal government. Since the airlines refused to stand up against these illegal orders, I have since stopped flying commercial airlines. What I want to focus on here is the case that was brought against Joe Biden and his CDC by Health Freedom Defense and others. In July 2021, Sarah Pope, Anna Danza, and Health Freedom Defense Fund sued various government officials and the CDC, seeking a declaratory judgment that the mask mandate was unlawful and to have it set aside for violating the Administrative Procedures Act. This is another example of why it is so important to go beyond the headlines. Now, all the reporting I've seen about a federal judge's ruling, judges don't rule, by the way, they opine, who struck down, that's not true either, the CDC's mask mandate, missed one very important point. The judge never found that the mandate was unconstitutional because the suit against President Biden and the CDC never asked her to. Now, the CDC claimed that Congress gave them the authority to issue the mandate under the Public Health Services Act of 1944, Title 42 of the United States Code, Section 264A. Now, reading from the opinion. Thus, if Section 264A authorizes the mask mandate, the power to do so must be found in one of the actions enumerated in the second sentence. That sentence provides for inspection, fumigation, disinfection, sanitation, pest extermination, destruction, and other measures. Section 264A. A requirement that individual travelers wear a mask is not inspection, fumigation, disinfection, destruction, or pest extermination, and the government does not contend otherwise. The Public Health Services Act, the PHSA, lists what the CDC can do to prevent the spread of communicable diseases. Mask mandates are not on that list. Now, the CDC claims that this mandate falls under sanitation and is therefore authorized by Congress. Instead, it argues that the mask mandate is a sanitation measure or an other measure akin to sanitation. The PHSA does not define sanitation. If a term goes undefined in a statute, courts give the term its ordinary meaning. Now, courts often start with dictionaries. Given that the statute was enacted in 1944, the court looked to dictionaries from the early to and mid-20th century to begin its analysis. They provide two senses of sanitation that are relevant here. First, sanitation may refer to measures that clean something or that removes filth such as trash collection, washing with soap, incineration, or plumbing. Second, sanitation may refer to measures that keep something clean. Redefining words to get them to mean something that supports your position is a standard practice in the legal profession. However, using a simple dictionary search, the court found that the CDC's definition didn't cover what they wanted it to. Put simply, sanitation as used in the PHSA could have referred to active measures to cleanse something or to preserve the cleanliness of something. While the latter definition would appear to cover the mask mandate, the former definition would preclude it. Accordingly, the court must determine which of these two senses is the best reading of the statute. Since the judge dealt with the question of the mandate violating the Administrative Procedures Act, or the APA, we should look at that as well. Notice and comment does not apply when the agency for good cause finds and incorporates the finding and a brief statement of reasons, therefore in the rules issued, that notice and public procedure thereon are impracticable, unnecessary, or contrary to the public interest. The mandate invokes this exception to forego notice and comment, so the court must determine whether a 30-day notice and comment period was impracticable, unnecessary, or contrary to the public interest. This exception is to be narrowly construed and only reluctantly countenanced. It applies only in emergency situations or where delay could result in serious harm. Congress, when it illegally delegates its lawmaking authority to the executive branch, puts rules in place as to how an agency could go about making those rules. One of those requirements is that there be a 30-day period so that the people would be aware of the new rule and have the opportunity to comment on it. Now, it should be a surprise to no one that the federal government gave itself away to get around these pesky rules. If the rules are impracticable, unnecessary, or contrary to the public interest, Congress said it's okay to ignore the notice and comment period. Of course, who determines what is and is not necessary or impracticable? Who decides what is in the public interest? According to the CDC, in this case, they do. But what did the court find? Specifically, the APA requires that an agency invoking good cause incorporate its finding and a brief statement of reasons why it believes notice and comment is impracticable or contrary to the public interest. Courts do not defer to the agency's conclusion on good cause. The court's review of the CDC's determination that good cause exists is limited to the grounds that the agency invoked when it took the action. The court may not supply a reasoned basis for the agency's action that the agency itself has not given. The mandate asserted that there was good cause to dispense with prior public notice and comment because, given the public health emergency caused by COVID-19, it would be impracticable and contrary to the public's health, and by extension, the public's interest to delay the issuance and effective date of this order. This statement, without more, is insufficient to establish good cause to dispense with notice and comment. In other words, the CDC said that there was good cause because, in their opinion, there was. Thankfully, the court disagreed. The APA also prohibits rules and regulations that are arbitrary and capricious from the opinion. Plaintiffs raised three arguments on why the mask mandate was arbitrary and capricious. First, plaintiffs argue that the mandate failed to comply with 42 CFR section 70.2. Second, that the mandate was substantially unreasonable. And third, that the mandate failed to adequately explain the CDC's reasoning. Because the court agrees with plaintiffs that the CDC failed to adequately explain its reasoning, the court need not address whether the substantive decisions embodied in the mandate were themselves arbitrary and capricious, or whether the mandate violated 42 CFR section 70.2. In short, the court says that since they've already found that the CDC did not adequately explain its reasoning on bypassing the notice and comment period, they didn't need to deal with the question of arbitrary and capricious. It was already done. Now, reading the judge's conclusion, it is indisputable that the public has a strong interest in combating the spread of COVID-19. In pursuant of that end, the CDC issued the mask mandate, but the mandate exceeded the CDC's statutory authority, improperly invoked the good cause exception to notice and comment rulemaking, and failed to adequately explain its decision. Because our system does not permit an agency to act unlawfully even in pursuit of desirable ends, the court declares unlawful and vacates the mask mandate. Now, once again, we see the conflation of the federal government with the public. Now, whether or not we have a strong interest in combating the spread of COVID-19, that does not mean those in government have that interest as well. Based on the actual data from the CDC about the dangers of COVID-19, I could even dispute how strong that interest might be. In either case, the court found that the CDC had gone beyond the powers delegated to it by Congress and violated laws regarding the rulemaking. Now, for that reason, the court declared, actually the judge opined, that the mandate was unlawful and therefore vacated. The one question that was neither asked nor answered was, is the CDC's mask mandate constitutional? Because as the supreme law of the land, if the mandates are unconstitutional, there's much more at stake than being forced to wear a mask on public transportation. For any act of Congress to be valid, it must be made pursuant to the Constitution. At least that's what Alexander Hamilton said in Federalist Papers number 78. There is no position which depends on clearer principle than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. So if an act of Congress, contrary to the Constitution, cannot be valid, we must start there. Now, the 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Therefore, the first question that should be asked about any federal law is, does it exercise a power delegated to the United States by the Constitution? That includes, by the way, the Public Health Services Act, Title 42 of the United States Code, Section 264A. The opening sentence of Section 264A grants the CDC power to issue regulations that, in its judgment, are necessary to prevent the spread of communicable diseases. Is the prevention of a spread of a communicable disease a power delegated to the United States? No. Is the regulation of public health delegated to the United States? No. Is regulation of public transportation a power delegated to the United States? Again, no. Now, some may claim these powers exist under the General Welfare Clause, but that is not what Article 1, Section 8, Clause 1 of the Constitution says. It says, the Congress shall have the power to lay and collect taxes, duties, imposts, excises, to pay the debts, and provide for the common defense and general welfare of the United States. Not only is the general welfare in this clause limited to the United States, the proper noun for the Union of States, and exactly the same subject as in the 10th Amendment, but this clause is limited to collecting taxes, not regulating them. As James Madison said in Congress in 1792, if Congress can apply money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take care of religion into their own hands. They may establish teachers in every state, county, and parish, and pay them out of the public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provision for the poor. They may undertake the regulation of all roads other than post roads. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress, for every object I have mentioned would admit the application of money and might be called, if Congress pleased, provisions for the general welfare. Now, others may claim that Congress and the CDC act under the necessary and proper clause. Once again, that is not what the Constitution says, this time in Article 1, Section 8, Clause 18. Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested in this Constitution in the government of the United States or in any department or officer thereof. Congress only has the power to enact laws necessary and proper for executing the power the Constitution has vested in the government of the United States, not whatever they think is necessary. So if the United States has not been delegated the power to regulate the public health or prevent the spread of communicable diseases, the PHSA is not a valid law and therefore void. Not only according to Mr. Hamilton, but the Supreme Court as well in the Marbury versus Madison opinion. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. Now, as I asked at the beginning of this episode, what does this mean for the American people? If the judge is correct, and the only problem with the mask mandate is that it wasn't implemented properly, well, then there's nothing stopping either the CDC or another agency from reinstituting it, as long as they follow the Administrative Procedures Act. If, on the other hand, I am correct, and the PHSA itself is unconstitutional and therefore invalid and void, then we, the people, never needed to follow it in the first place. The CDC, the states and cities that run the airports, the airlines, and everyone else were following a law that did not legally exist. That makes it just like all those who were afraid to say anything when the emperor walked around with no clothes. It's worse than that, though, because they also committed a federal crime under Title 18, Section 242 of the United States Code. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year or both. Now, for those who used violence in an attempt to get people to comply with this invalid order, well, things could get worse. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or both. Now, you may be asking, what rights, privileges, or immunities protected by the Constitution are violated by a mask mandate? Well, from the Fifth Amendment, we read, "No person shall be deprived of life, liberty, or property without due process of law. If you are forced to wear a mask because of a law, statute, ordinance, regulation, or custom, you are being deprived of the liberty to live your life as you see fit and the property you have in the control of your body." Now, since no one bothered to safeguard your rights during this process, you did not receive due process. An established course for judicial proceedings or other governmental safeguards designed to safeguard the legal rights of the individual. These mandates are not based on a person's actual infectiousness or danger to others. It simply assumes everyone is guilty of being a danger to others and therefore must have their rights restricted. Once again, we see that Founding Father John Jay was correct. Every member of the state ought diligently to read and study the Constitution of his country and teach the rising generation to be free. By knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. Perhaps, if we take this opportunity to learn our rights now, we can avoid such an infringement on them in the future. Some people say the devil is in the details, and that's pretty much true. See, while some people have lauded what the judge has done and others have vilified it, very few people actually understand what the judge actually did. The judge said that the CDC did not follow the law when they created the rule. They never noted that the rule itself was unconstitutional. That if the CDC were to follow the Administrative Procedures Act, or if another agency were to attempt it, it would still be illegal because it violates the supreme law of the land, the Constitution of the United States. It also proves why it is so important that we, the people, read and study the Constitution of our country, that we know what our rights are, that we're prepared to defend and assert them. It's one thing to sit back and say, well, that's unconstitutional. It's another to be able to stand up and say, no, I can prove it, and I'm willing to live by the Constitution, not your meaningless, void law. It's very liberating to learn this, and you can join us. As I mentioned in the beginning, I'm putting together a 2022 tour. I'm still looking for dates and venues. If you would like me to come speak to your group at your event, you just think there's a place, it would be a great place for me to visit, please head to constitutionstudy.com/tour and fill out the form below. If we can make it happen, I would love to come visit you. I've already got a couple people that are talking to me about putting events in place, and I'd love to get you on the schedule. Again, go to constitutionstudy.com/tour to find out more. Also, would you please share the video, the audio, the article, take these resources and share them. Right now, what we need most of all is people to be aware of their rights, to know that something is wrong and that there's something they can do about it. And the first step in that is showing them. Maybe you're not ready to lead your own Constitution study. Maybe you're not ready to get up and fight, but you can share this information. We can find others that are. See, it's not simply the person who leads, it's the people that support them that get the job done. Now, if you'd like to learn more about the Constitution, please join us at the Constitution Study. I'm still doing my online study. Just go to constitutionstudy.com/study and find out more. You can even try it absolutely free. I do 3 lessons on the Bill of Rights, and you can try them absolutely free. If that's all you want, that's wonderful. If you want to join us for a more in-depth study through the rest of the Constitution and the Declaration of Independence, all the information is there. Once again, that's constitutionstudy.com/study. Whatever path you take, whatever tools you use, I ask you to do one thing. I ask you to be involved to whatever extent you're comfortable, whether that's reading and studying, sharing, or just voting. Let's realize we are in an election year, and who you choose, especially in your local government, will have a tremendous impact on how free you are for the next couple of years. So let's take all that into consideration. Share these videos, help others. Let's find others that are interested. And when you find them, bring them along to join us here at the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from